and this week we've got the very exciting topic of workplace monitoring. It's something which I think is going to increasingly go up the importance list for all employers for a number of reasons. First of all, as Vanessa will discuss in a minute, the types of monitoring are increasing significantly, and the technology behind it and the technological sophistication of the monitoring is increasing massively, as is the legal framework. Regulators, etc., are getting much hotter on this. So we need to look at that legal framework and how that's going to work. So there's quite a lot of important things to say about this subject. Cases fairly few and far between at the moment, aren't they? Yeah. But we've got 3 cases which we're gonna look at, and then finally back to the legalities of this, looking at the data protection framework around this, which is really where I think for most of us we're going to find the regulatory requirements. So we're going to look at those issues and see where we get to. But we'll start with looking at the types of monitoring that are available.
Thank you, Matthew. So yes, we've got lots of different types of monitoring up there for us to consider. Some of them more traditional, for example, the physical searches, and some of them more technological, and increasingly we're finding as the technology comes, perhaps we could say more intrusive for the employee. So we've got on there, I won't go through all of them, but for most of them we've got access panels. So of course this is accessing the workplace, and these tend to either require your normal passwords or a swipe card, but also a number of them also now require, say, fingerprint, an employee's fingerprint, and that then brings in the issue of, well, you're actually using biometric data of the employee, which of course takes us into the data protection sphere.
Yeah, and face recognition and voice recognition, I suspect, as well.
And eyes, and all sorts. Yes. But also access panels can, especially in the US, are being used for more intrusive extreme levels of monitoring, such as tracking employees' behaviour around the workplace, in particular access panels before you enter the toilets or before you enter the breakout rooms to check how long employees are spending in those places. So that's access panels. We have obviously time and attendance monitoring, which has been around for quite a while. Attendance is obviously a key part of an employee's productivity, and so we monitor attendance to obviously capture lateness, but also looking at sickness levels, and we monitor it also to look for patterns and absences, whether it's per department, types of during particular types of parts of the year. So, and when we're monitoring that, we could use like a time clock or via the computer itself as well. And so time and attendance monitoring has been around for quite a while, hasn't it? Filters and firewalls, so they not only prevent outsiders from getting into an employer's IT system, but also can prevent employees from accessing certain websites unrelated to work as well. So they're used. We also have the telephone and voicemail monitoring. Some employers do monitor employees' use of telephones, particularly where they're kind of in a call centre. Obviously, is the obvious example there. And so they're monitoring both productivity, but also communications with clients and such for to check orders and order. And also in the financial sectors, also just checking there's no breaches of any regulations as well. So we see quite a lot of telephone monitoring. Video surveillance and CCTV, I won't say much about that at the moment, because actually they've got a couple of cases that I'm going to talk about in a little while, which talks about CCTV. So we also have desktop monitoring programs on the computers, and this can monitor and record every keystroke an employee may make. Can track also different applications that they may use, can track documents access, how long they're spending in a document, all sorts of data can be gained from monitoring employees' desktops. We also have the classic one, which is email monitoring, which comes up quite a bit with clients. It is very common, and sometimes searches can be made for if there's any kind of particular words, key danger words or destination addresses or something they want to check. But also it's just they use a lot in terms of perhaps there's been a grievance for a discrimination allegation, and emails are monitored to see if there's any evidence which will help the investigation. But what's quite interesting with email monitoring is, of course, whilst a user may delete the email, we'll know that they can be retrieved.
Yes.
And even once the employee's long gone, they could still potentially be retrieved by using experts. And the other thing is, of course, is that there are some email monitoring systems that are so sophisticated that actually they not only monitor the workplace email account, but they can also monitor personal email accounts if they use it going through use their Yahoo or Gmail or whatever account through their company systems, and that obviously does take us into issues of privacy. Physical searches, as I said at the beginning, one of the most traditional and perhaps shall we say old-fashioned type of monitoring, but of course they are still used, in particular where there's concerns as to have employees being in possession of drugs or alcohol, and also for theft as well. And also you look into the searches of wanting to search staff members' bags or lockers, and we also have the issues of privacy there to consider.
One of the things I've found there is mobile phones, searches to actually ensure mobile phones are removed before the employee sits down and does their day's work because of the particular nature of the work. Particularly if they're in sensitive call centres or similar.
Yes, because of the good old mobile phone with the ability to take photos and capture all sorts of information.
Absolutely,
yeah. Social network monitoring. I'm sure there's a number of us who've Googled perhaps potential candidates' names or employees' names, looking at also Facebook, LinkedIn, that kind of thing. So those that is obviously a type of monitoring of your employee. Search engine, website browsing monitoring. Programs are often used in workplaces to block, as I said, access to certain websites. But it is possible for employers to see which websites have been used, obviously via cookies and also web prints as well. It's used to, again, look at productivity. Is the employee spending all the time, shopping on the internet when they should be working?
Are they looking for another job?
And to check for any inappropriate activities that they might be doing on the internet and browsing. And the last one I was going to mention, which is tracking, and that does come up for a few clients as well, depending on the nature of the business, particularly those that have tracking devices on company vans, company vehicles. So that's a classic example of tracking. But also tracking can be used not just to monitor vehicles, but also can be used on their phones, on their laptops to track employees' movements. And of course, we have to be a little bit careful there as well. Tracking during working hours is one thing, but if that tracking device remains on and is monitored after work and an employee's gone to lead their private life, then that is another issue that needs exploring and considering. So I think what we get from there is there are all different types of monitoring that currently go on. And moving forwards, I think there's a lot more that's going to come along. And what does the future hold? Well, there's been a number of companies that have sprung up over recent years to try and insist and develop products for employees, for employers to continue to monitor employees in a potentially more intrusive way. Some ideas have been developing a biometric staff badge, which uses a microphone to conduct real-time voice analysis, contains sensors so you can track your staff's movements around the office, and with actual motion detectors around the office as well. The idea behind this is actually to measure stress levels, but obviously I'm sure a number of us are a bit cynical as to the intention behind such wearable devices.
Stress is likely to go up, presumably, if you think you're being monitored 24/7.
Absolutely, yes. And then there's another company called Terramond who uses a live analytics dashboard and actual live streams of employees' desktops to monitor them. And so they monitor everything from productivity to the work that they're doing and file transfers and instant messages that they might be making. And it has a feature that allows managers to kind of play back the activity at any point that they may want to do so. And I think the other point I was going to just say is, IT usage outside the workplace has, of course, increased with the growth of home working. Lots of employees work at home. Lots of employees bring their own devices to work. And of course, these technologies can pose a risk to the privacy of employees, because monitoring systems that might be in place actually at work then through this way actually end up in their home life as well if they're working from home.
Yeah.
So yeah, what else does the future hold?
Well, it's all getting quite scary, isn't it?
It is.
I think when we start to look at some of the, as Vanessa said, some of these things are about stress and trying to keep stress levels down, and that all sounds very benign. But certainly, looking at wearable devices and wellness monitoring, there's a lot of information being collected about an individual and how they actually function and what their health is like, etc. And I think that's something which is likely to be a big one for the future. And that's where we start to look at automated decision making and predictive technologies, which are both things which are very much on the radar of the Information Commissioner. So automated decision making, very much what it says, where effectively decisions are made without any intervention from humans. And this again is likely to have a role to play in monitoring, and we have to be very careful about this, because what's being shown is that some of these technologies seem to have inbuilt discriminatory factors to them. So, for example, face recognition software seems to have a bias towards or bias against BME people. So there's some real issues around automated decision making, which and just how reliable and acceptable the technology is, which I think are going to lead to quite a lot of head scratching in the future. The other one, predictive technologies, which again, this sounds real Big Brother stuff, because this is where actually the monitoring of behaviours is done to predict how people will respond in particular situations in the future. And if you're being monitored by having a load of wearable devices and by your employer having access to your screens, etc., the types of data that they will be picking up may be used to take decisions about your future employment. And that again is something which the Information Commissioner's Office in particular has real concerns over. So this is a sector which is moving very, very quickly indeed, and it has quite significant legal issues around it, which I think we're going to see the ICO struggle to keep up with to a certain extent. And that's where we start to perhaps have the interaction in particular with data protection law. But I think it's probably a good time just to have a look at the legal framework, because there are a number of pieces of legislation here which have a resonance. The obvious one is the Data Protection Act 2018, came in last year on the back of GDPR, and provides a greatly enhanced list of rights for individuals in terms of their data, obligations on data controllers, which is all of us as employers, as to how they process that data, and also powers of the Information Commissioner to ensure that data is being properly used. We'll look at data protection in a bit more detail a bit later, but just to touch on some of the others, just to mention there of the Investigatory Powers Act 2016, that piece of legislation, and actually another piece of legislation as well, the Regulation of Investigatory Powers Act 1998, are really about either permitting or trying to fetter the powers of the intelligence service, the police, and actually under the Investigatory Powers Act, even in some circumstances, local governments, to be able to investigate how they can survey individuals, what kind of monitoring they can do. It can have some resonance for us as employers in terms of who might have access to the results of our monitoring, and in certain cases, public bodies can come in and demand that information. In some cases, it poses criminal offences on us as employers or us as monitors in terms of interception of transmissions in particular. We have to just be a bit careful about that. And in some cases, it also gives rights to individuals. So we just have to be aware that actually much of our monitoring, I think increasingly when we're looking at our monitoring, much of it is actually there is this impact from intelligence services related laws in this area as well. So we just need to be aware of that. Human Rights Act, of course, very relevant. New cases you're talking about are really around human rights issues, because of course what the Human Rights Act does is enact the European Convention on Human Rights into UK laws. If you're a public authority as an employer, then you have to ensure you adhere to the European Convention. You have to take it into account. You don't have to quite in the same way if you're a private sector employer, but what we need to understand is that when the courts and the tribunals come to look at rights in this area, they have to interpret existing laws through the prism of the European Convention on Human Rights. And in particular, what they're doing there, what they're very alive to is Article 8, right to a private life. And of course, monitoring, surveillance somehow impacts upon right to a private life. We've added Equality Act 2010 there, really because of the point I made earlier, which is that we can't assume that monitoring and surveillance are equality neutral technologies. And increasingly what we will find is that there are equality issues raised by the types of monitoring and the types of decisions we're taking on the back of that. I gave the example earlier of facial recognition. That's one of many. If you're taking decisions based upon someone's postcode, for example, and there is a particular ethnic bias in that postcode, then the types of automated decisions that can be taken, or predictive decisions that can be taken in particular, may end up with a bias built into them. So it's a very much a developing area, but one we're going to have to keep an eye on. So that's the legal framework. I suppose we could add unfair dismissal law. There's a role there, and I think you might be looking at a case which involves that. And also just trust and confidence and contract issues. Again, there's a role to play. But I think you're going to have a look at a few of the cases now.
Yeah. So we're just going to look at a few cases on this, and as we said, they all kind of centre around Article 8 and the right to privacy. And really the case law on the right to privacy tends to focus on the question as to whether first the employee had a reasonable expectation of privacy in relation to whatever communication we're talking about. And if there isn't that reasonable expectation of privacy, then that Article 8 isn't engaged. If they did have a reasonable expectation of privacy, then the court then goes on to consider whether the interference with that privacy was in accordance with the law, and in particular whether it was proportionate. And so this is really what this case is looking at. And this case considered an employer's monitoring of an employee's Yahoo Messenger account. So the claimant was a sales engineer, and he's working for a private company in Romania. And he was dismissed for personal internet use at work. The company itself had a very strict internal policy and a very clear policy which strictly prohibited all personal use of IT at work, and in particular no internet use. And as part of its investigation, the employer, because they suspected that this employee had used the computer system for personal use. So as part of its investigation, they actually accessed messages which he'd sent to his fiancée and also to his brother. And this was on a work-related Yahoo Messenger account. The account in question had been set up for work purposes, and as I said, the employee denied any personal use. But the employer had also, as part of their investigation, accessed messages that the employer had sent using his own personal Yahoo Messenger account, but on the employer's computer systems. These messages were in evidence, had been printed by the employer, and they were used in the disciplinary proceedings and of course in the subsequent court proceedings. And the claimant, the employee, also complained that the transcript of these messages had also been sent to a number of his colleagues. So he was obviously dismissed, and the case went to the Romanian courts when he complained about in relation to his dismissal, and the court upheld the dismissal. The Romanian court upheld the dismissal. But what happened is that the claimant then alleged that the monitoring of his communications had breached his rights under Article 8, and that the domestic authorities in Romania had failed to protect those rights. So the case then went to the European Court of Human Rights to consider, and it initially held that any interference with the claimant's Article 8 rights was actually proportionate. And at the time, this was a very controversial decision. Part of its rationale was that it wasn't the content of the messages that had been important before the domestic court. It was the fact that they existed, i.e. who'd been using the IT systems for personal use. And obviously their existence proved that there'd been personal use of the employer systems. But then the Grand Chamber of the European Court of Human Rights reversed this finding last year. And they found that the Article 8 rights, the right to privacy, actually has been infringed as a result of the employer's actions. And what they said is quite interesting, is that they said that just because an employer might have an instruction, that can't actually just reduce private social life in the workplace to zero. it is inevitable that employees are going to come to work but still have a private life that they're going to lead in some form or another in the workplace. So basically, an employer can't simply grant itself an absolute power to invade privacy by putting in place draconian policies. And they actually helpfully set out some factors to be considered when assessing the monitoring of workplace communications, and that includes, which is quite sensible and I'd say quite predictive really, but clear advance notification about the potential monitoring, and in particular the extent of the monitoring. And I think the issue here was actually they didn't actually say to the employee the extent to which he may be monitored. Has the employee got a legitimate reason for the monitoring? And actually whether a monitoring system based on less intrusive methods rather than directly accessing communications would have been possible. What are the consequences for the employee, and also whether the employee has been provided with adequate safeguards. So it's a useful case because it reminds us of the different factors that need to be considered when looking at implementing and carrying out workplace monitoring.
And it's all about proportionality, I think.
It is.
It's, you know, even if you look at Article 8, it doesn't say you've got an absolute right to a private life. You have a limited right to a private life.
Yeah.
So.
Yeah, and they found that basically, you know, there was a breach because they failed to strike that balance, that proportionality between the business interests of the employer and the privacy rights of the employee. So then moving on to the next case, and I'm going to talk about two more cases, and both of them actually talk about surveillance and covert surveillance. It's two interesting cases to look at back to back, actually. So this one, again, involved Spain, and it went to the European Court of Human Rights. But what happened here is that the company was a supermarket, and they noticed over time that they were losing quite a significant amount of money. So they decided to put in surveillance cameras. But they put in several visible surveillance cameras around the supermarket. What they also did was put in place some covert surveillance cameras aimed at detecting theft by staff. Obviously, the visible ones for customers, but the covert ones for staff. The employees, importantly here, weren't informed that those cameras, the covert ones, were in place. 5 employees were caught on the CCTV stealing items and also helping customers steal items, and they admitted involvement in the theft and they were dismissed. They claimed unfair dismissal. The Spanish court upheld the dismissal, and then the employees argued that the use of the covert video evidence in the unfair dismissal proceedings had infringed their privacy rights. And they also claimed that actually that it infringed their right to a fair hearing as well. So what did the European Court decide? Well, they found that the employees' failure to inform the employees in advance of the installation of the surveillance system was a real issue here, and meant that Article 8 rights had been infringed. But they also found that the employer hadn't given the information required by Spanish data protection law. So they looked at the relevant data protection law in Spain and found that actually no, the company hadn't followed that either. And they considered that when looking at the Article 8 rights. And this was the case even though it was, of course, that surveillance that directly led to the employees being dismissed because they were caught stealing. And they said that the court said that covert video surveillance of an employee in the workplace must be considered a considerable intrusion of private life, since, of course, an employee is contractually obliged to report for work at the workplace and can't obviously avoid being filmed in the workplace. And therefore, Article 8 had been engaged. So Article 8 has been engaged. Next question you have to consider is, of course, is there a fair balance? Was it proportionate? And they found that the Spanish courts had failed to strike a fair balance between the employee's right to respect for a private life and the employee's interest in protecting its property. And they found that the employee's rights could have been safeguarded by other means, notably by informing the employees in advance that there were going to be these cameras. They did find, because they considered obviously the right to the fair hearing point, and the European Court did find that because video evidence wasn't the only evidence the domestic courts had relied upon when considering the dismissals and upholding the dismissals, they found that the right to a fair hearing hadn't been infringed. You know, when we look in the UK and we look at the ICO guidance, they really don't like covert monitoring, do they?
No, they don't. No.
They say it'd be very rare for it to be justified, and really, it's only in those cases where, you know, there's a real suspicion of criminal activity.
Yeah, but it's an odd one, isn't it? Because, you know, if you tell the employees, then they won't steal.
Yeah, exactly.
You don't really want just to have employees who have decided not to steal because they're going to get caught.
Yeah. Yeah, and then they'll find ways of working around the cameras.
Yeah, exactly. So I think a lot of people thought this was a bit controversial as a judgment, but it is sound, I think.
It is. It really is. Yeah. So the final one we're going to have a look at, we're back to the UK, we're back to the Employment Tribunal and the Employment Appeal Tribunal. So this, again, looked at covert surveillance. So this involved Mr. Gale, who worked for the City and County of Swansea Council. And he was twice spotted by a senior colleague playing squash at his local sports centre, when in fact he was saying that he was at work. Very naughty. So the council had this information and they decided to hire a private investigator. And the private investigator covertly filmed the employee leaving the sports centre on 5 different occasions. So he was filmed outside of the sports centre, obviously in a public area. The council, unsurprisingly, dismissed him for gross misconduct, and rather silly in my view, but anyway, the employee decided to bring a dismissal claim. So the tribunal considered the claim in the first instance, and they found that the council had genuinely and reasonably believed that the employee had been deliberately claiming payment for time when he wasn't actually working, and this therefore potentially justified his summary dismissal. However, they found the dismissal to be unfair, and they found this on the basis that they considered there was no legitimate reason to put him on covert surveillance, because they thought, well, he's been spotted playing in the squash club twice, that's enough to go through, that's enough information to go through and uphold a decision of misconduct and dismissal. They found that the use of covert surveillance was unnecessary and disproportionate and constituted an unjustified interference with the employee's right to privacy. The council appealed, and of course it goes to the EAT, and the EAT disagreed with the tribunal, and they first of all found, quite importantly, that there wasn't a right to privacy here because of the wrongdoing. And they found that the employee didn't actually have a reasonable expectation of privacy because, of course, the video footage was of him in a public place. And actually, it was obtained during a time when he should have been at work, i.e. in the employer's time. And they also found that the surveillance was actually irrelevant to the dismissal, really, because when you look at misconduct cases and dismissals, the tribunal is required to consider whether the employer had reasonable grounds following a reasonable investigation for its belief in the employee's guilt. And only if faults in the investigation are relevant to the dismissal can that then render the dismissal unfair. But here, the tribunal's finding that the council had acted disproportionately because it didn't need to rely on the surveillance, in addition to the other oral evidence of the misconduct, i.e. the citing by a senior manager. They found this was irrelevant to the unfair dismissal claim. And they further commented that it's never likely that an investigation will be held to be unreasonable because it's too thorough. At least without that investigation having some way or other made the dismissal unfair. So I think this is an interesting case, especially when you, as I said, you put them back to back, and it just shows that, as with many cases, always it's very fact sensitive and depends, and it depends on the facts of each case. But it does give a useful indication as to the exceptional circumstances in which covert surveillance may be used to confirm an employer's suspicion of wrongdoing. And of course, I think the relevant factors here, of course, the surveillance was in a public place and actually during work hours.
Do you think we have to be a bit careful of this case now, because of course it predates the Spanish case?
Yes, that's true.
Where we've got, does fraud trump privacy? And in this case, the EAT were very much yes, it does, absolutely. You can't, it's not a rogues charter. Whereas the Spanish case seemed to take a slightly, I think, perhaps different view. So,
and of course that was theft as well, wasn't it?
Absolutely, yeah. So I think we just need to be. It's a useful case, and certainly one we would be looking to rely upon. I think in a similar case, but I think we could see the Rivalda and Spain case argued against us.
Okay, And again, it will, as I said, it will turn on the facts.
Yeah.
I think the issue with the other case, of course, is the surveillance and such. It
Absolutely.
was not time limited against all, all employees, whereas this was. Very different.
Yeah.
So we'll see what the next one brings whenever it comes.
We will see what the next one brings. And I think, as the Ribalda case shows, the European Court placed a lot of store on the fact that the Spanish supermarket hadn't complied with the local data protection framework. So I thought it would be worth us just looking at what that means in the UK. So of course, we're in this slightly odd position with data protection at the moment, in that we've had this seismic change to the regime in terms of GDPR coming along, but the ICO are still trying to catch up from a regulatory point of view of that. So we're actually got a document here. It's the Employment Practices Code. Very interesting, very important document, useful for all employers, and I thoroughly recommend that you're familiar with it. But it's under the old regime. It's under the 1998 Act rather than 2018 Act, so we can expect it to be updated at some point. But this has things to say on a number of aspects of data protection in the employment field. But there's a whole section, part 3 of the code on employee monitoring. And I think from a Data Protection Act, it's just worth looking at where the real issues here are. Just an aside, important point, what type of monitoring are we looking at? Are we looking at systematic monitoring, i.e. it's put in place permanently, it's put in place as part of the workplace practices of the employer, or are we looking at something which is ad hoc, such as the supermarket cameras? Well, they should have been ad hoc to try to deal with a particular instance, particular event, particular suspicion. And I think probably the requirements around each of those, the regulatory requirements around each of those, are slightly different. Certainly, when we are looking at systematic monitoring, we're looking at that in the context of GDPR, context of Data Protection Act 2018. We really need to be looking at having very full impact assessments, reminding ourselves that GDPR requires us to look at privacy in the way in which we design the systems, privacy by design or default, and ensuring that it's taken care of at a very early stage. Perhaps not quite the same with ad hoc monitoring. So we need to remember that the fruits of the monitoring, whether it be surveillance video, whether it be data about keystrokes, whether it be recording somebody entering or leaving premises, all of that is personal data, which will belong to the individual data subject, the employee. And what that means is there must be a lawful basis for processing that data, so a lawful basis for that monitoring. We may be able to rely upon contract as the lawful basis. We have a contract with our employees, and that can be a useful one. But we have to be a bit careful about that. And I think increasingly what we're doing is we're relying upon a separate lawful basis, a bit of a catch-all known as a legitimate interest, i.e. we have a legitimate interest to ensure that our employees are acting honestly, or that stock losses are kept to a minimum, or that we can effectively understand work patterns or peaks and troughs in work. So it's a legitimate interest rather than contract, I think, in many of these cases. And there was a quite interesting case around vehicle telematics in Germany recently, which looked at the lawful basis here and really supported that view that the contract per se did not justify that. You did need to look at another lawful basis. If we are using legitimate interests, then we need to remember that we need an impact assessment to justify that, and that needs to be in writing. So for all forms of monitoring that we're doing, whether it be from swipe cards on the doors through to keystrokes, through to being able to look at web searches conducted, we need to make sure we understand their data and that we have got our impact assessment on our lawful basis. We always need to ensure that we've got proportionality. We've seen this in the context of the Article 8 cases that Vanessa picked up. We should only be doing something if it is justifiable in those particular situations. There we need to be careful. It's a point Vanessa made in the context of the Barbulescu case, but it's also a case that the Information Commissioner makes in the Code of Practice, which is that all forms of surveillance are intrusive and therefore have a degree of harm associated with them. So effectively, the ICO starts on the basis that we should not be monitoring, we should not be surveying and then you sort of justify why you need to. So that whole issue of proportionality is really, really important, and that again feeds into your impact assessment. And again, the ICO recommends a separate impact assessment whenever you're looking at any kind of surveillance or similar activity, which will look at what the detriment to the employee is against the benefits of the surveillance itself. We need to look at record keeping. We've talked about having impact assessments. They need to be in writing. We also need to ensure that, and again, it goes back to the Romalda Spain case, that we have taken this into account in our privacy information notices, that we've taken it into account in our general record keeping of our data flows and our data maps. So there needs to be good record keeping. And that also feeds into the last point, which is what do we do about informing the employee? Again, any systematic monitoring that we're doing, so any routine monitoring which is set up for a long-term basis, again, should be mentioned in our privacy information notice, so the employee has got absolute visibility of what is happening. Clearly, we need to go further than that. If we're looking at CCTV, for example, then we need to be looking at making sure notices are placed around so employees know when they are going to be surveilled or not. The circumstances when you will not be informing the employee because of wanting to catch them out for a theft or similar will be very few and far between. Obviously, you won't be necessarily informing the employee that you're doing that in advance, but that is really where we need to be very, very careful about making sure our impact assessment is done so as to justify that. And that will keep us on the right side of the Data Protection Act. And if we're on the right side of the Data Protection Act, then we should avoid the sorts of issues that came up in the Spanish supermarket, in the Spanish supermarket case. So really, when we're looking at this, the most immediate form of legal regulation for all of us is the Data Protection Act, and we just need to make sure that we're following that code. So worthwhile having a look at the code if you're looking at doing this. Certainly for the future, if you're looking at introducing any further monitoring or any further surveillance, then absolutely vital that you've conducted that impact assessment. Absolutely vital that you are on top of the privacy by default and design, and that you're building it in at a very early stage in the process. And again, most vendors of this kind of system should now be on top of that. So what do we conclude? Monitoring is all a bit scary. It's becoming, it's becoming a bit scary just with the way in which I think it can happen and increasingly will happen in the workplace, just because of the vast amount of data that can be collected and the increasingly inventive ways that there are to get that data from us. So it's something which is very much on everyone's radar. It's a business imperative to ensure that people are acting properly and appropriately at work. Monitoring has a role to play in that, but we cannot take it too far. No. We need to recognise that employees are entitled to a private life at work. That sounds a bit oxymoronic, but there is that recognition, and the and okay, that Swansea case perhaps maybe takes perhaps a slightly out of fashion view now on that, do you think?
Probably. Yeah.
So we have to be a bit careful about that because of the fact that there is this very blurred line. And I think where the regulators and the cases are getting to there is they're really saying, well, look, everyone comes in and at the lunchtime they go onto their computer and they look at their Gmail accounts, or they go and do their private banking or whatever. You can't really avoid that. We have to recognise that there's a personal aspect to that. We've made the point, we'll make it again. The regulators are taking this area very seriously, and I think we will see more activity. We will see the code of practice being updated at some point, and be interesting to see what that looks like. And more court challenges. I think we can expect any case which involves a degree of surveillance, inspection of systems, potentially impacts upon the individual's private life in some way, for that now to be an issue that they bring up as to why their employer has acted improperly.
Yeah, absolutely. Yeah.
Okay. Right. Well, I think that is very much us for today. We hope you have Enjoyed that, found it interesting. If you've got any follow-up questions or anything you'd like clarification on, then feel free to contact either of us. Our details are on the screen there.